Am I audible? Am I
Yes, sir.
audible?
Yes, sir.
We'll start in 5 minutes. Yeah.
Good evening, everybody.
Good evening, sir.
Good evening. I am N.R. Nayak here, President of Teachers Law College and practicing advocate here at Bangalore. Today's topic is relating to the maintenance. Are you hearing?
Yes, sir, we can hear.
Yes. Thank you. Today's topic is relating to the maintenance of wife, children, husband, and parents. All these topics are in different acts where we are going to get maintenance from which act, whether all these acts are applicable for maintenance to the children, wife, parents, and husband is also entitled along with the wife. So therefore, these sections are very much important. Now, formerly, when I was started the practice, there are two acts. That is Hindu Marriage Act, Section 24. So Section 24 says, wherever the petitions are filed for relating to the marriage is concerned, during pendency of those proceeding, that is divorce petition and next restitution of conjugal right and custody of children, JNWC, all these proceeding, we can file application under Section 24 seeking for maintenance, because during pendency of the litigation, whether the parties are earning or not, that is also looked into, and based on the duty of the persons, duty of the family members, how to be assessed. So therefore, under Section 24, during pendency of the proceeding, the the maintenance can be granted to wife, children. If the husband is not able to earn, husband is hospitalized. When wife is earning, he is also make an application during pendency of the proceeding relating to the marriage. Even husband is also entitled to get maintenance from his wife relating to the earnings of the parties. So this is under Section 24 during pendency of the proceeding only, and those proceedings are pending before the family court only at Bangalore, and other side the civil judge senior division having jurisdiction. Those proceedings are going to be conducted. Therefore, pendent lite, that is called as pendent lite, maintenance application can file under Section 24. Now, next section in Hindu Marriages Act, that is under Hindu Marriages Act, another one provision, permanent alimony. Permanent alimony you can get based on the income till two conditions are there. One is during lifetime. Second is remarry again. After divorce was took place, the maintenance is entitled. Therefore, if remarriage was took place between parties or other parties, automatically the maintenance is not entitled. So that is permanent alimony can be changes of circumstances. Now, when we are getting permanent alimony from her husband unable to give the permanent alimony, even pendently also unable to give, it is changes of circumstances based on the judge's assessment, based on the evidence placed before the court. Then only the permanent alimony can be granted. So under two circumstances, permanent alimony under section 26, 25 of Hindu Marriage Act, permanent alimony can be claimed. Now, yesterday I have filed a petition for permanent alimony because the wife filed a petition under dissolution of marriage due to cruelty ground. Therefore, when I don't want to go with him, I don't want to lead my life with him, therefore, I need permanent alimony because it is duty cast upon her husband. Therefore, permanent alimony I have claimed more than 1 crore 50 lakhs rupees. Because he is a earning member, he is a contractor, therefore I have assessed his income and I have claimed the permanent alimony because I sought for dissolution of my marriage against, because he is not cooperating. Several allegations are made on the ground of cruelty. Therefore, I need permanent alimony. I don't want to continue with him. That is called section 25 also operating against the husband. This is under Hindu Marriage Act. These are the two sections. Please note down Hindu Marriage Act 24 and 25 relating to the maintenance, wife, children, parents and husband. Husband is also entitled under these provisions either permanent alimony or maintenance can be granted by the court. Court is having jurisdiction over that. Now, another act is Hindu Adoption and Maintenance Act 1956. You see, when the child going to adopt, that is adoption procedure is there. Now in that act, the maintenance under section 18, maintenance of wife, that is called as Hindu Adoption and Maintenance Act 1956. Section 18 is relating to the claiming maintenance of wife. So wife is entitled under section 18 of Adoption and Maintenance Act 1956. She has also entitled to file application for maintenance. Now, specific section is also mentioned in the same act relating to the widow. Widow daughter-in-law can claim maintenance against in-laws. That is also section 19 Hindu Adoption and Maintenance Act. She is entitled to claim maintenance from her in-laws. That is section 19 of Hindu Adoption and Maintenance Act. Please note down all these things because it is helpful for you where exactly we can approach, under what provision we can approach for claiming maintenance. Therefore, I am specifically saying relating to the maintenance only today's topic. Now, section 20 is also available for maintenance of children and aged parents. Hindu Adoption and Maintenance Act, section 20. It is available for children and aged parents. Parents are also can file application under this provision before the jurisdictional court, either civil judge senior division in Mopsel area or before the at Bangalore, it is family court. You can file application for children or parents separately. You can file. These are the provision under Hindu Adoption and Maintenance Act. Now, another one section is available for this. Dependents. Who are the dependents? Wife depending upon husband. Mother depending upon the parents. Father. So likewise, dependents are also entitled under Section 21 of Hindu Adoption and Maintenance Act 1956. These maintenance available for the provision, because you see, always we are going for criminal. I will come later for discussion why these different sections are available for maintenance. I'll come later. But these are the sections you must notify that whether I should go 24, whether I should go 25 Hindu Marriage Act. So therefore, you think over that. Now client comes to you. They are Hindus. Now under Special Marriage Act, now you have to, which section you have to claim for maintenance. So therefore, another Special Marriage Act. In that act also you can claim maintenance under section 36. Alimony is pendent lite. Pendent lite under section 36 of Special Marriage Act, because they are not Hindus, therefore they are claiming under that section how the maintenance could be claimed from the husband or the parties to the proceeding under section 36 of pendent lite in a Special Marriage Act 1954. So therefore, these are the section you must apply when client comes to you, whether they are belongs to Hindus or belongs to Christian or belongs to other community. Therefore, the Special Marriages Act is also available for them. You can file the case for maintenance alimony pendent lite under section 37. Even 37 permanent alimony, 36 Special Marriage Act pendent lite, and 37 is permanent alimony you can get. When I have started the practice, because only one section is available for us, only 500 rupees fixed. In that section, that is called as 125 of CRPC, then. Now it is changed as section 144, because recent amendment CRPC changed as chapter 10, section 144, new section, but old section is 125. In that particular section, what happened? First is wife, second is children, third is parents. All the parties, they should file a case before the criminal court to claim maintenance, then. Because in olden days, there is no family court. Therefore, we used to file under section 125 proceeding before the magistrate court only. So the only 500 rupees has been fixed. Those 500 has been removed and it has been enhanced based on the income of the parties that was amended. Therefore, 500 rupees has been removed, deleted from that provision and substituted income of the parties to be assessed by the honorable judges. So therefore, section 125U Maintenance Act is very clear, and police authorities have been given to collect, to recover money. Through the police only, it used to collect the maintenance from them. So this section, earlier we are used to use against husbands, because 500 when it was there. Now it was changed. Therefore, now 125 proceeding also we are filing. 124 also filing. Adoption Act, that is 1819 also filing. All these sections are available now. Now new act, another act has been introduced. Domestic Violence Act. Under Domestic Violence Act, several interim relief can be granted, including maintenance also. Maintenance under section 20. The Women from Domestic Violence Act, Protection from Domestic Violence Act, that is also section 20 is available for maintenance. Now, main question in your mind, it may be, I think maintenance, all the sections are available. Where should I go? Definitely it is in your mind. That is, you can assess First of all, which proceeding initiated? Whether 125 initiated, because always we used to practice first 125 only, because I don't want to give divorce, I don't want to give claim restitution, but I must get maintenance from my husband. Therefore, we used to get section 125 only. And section 144 now newly amended, because Bharatiya Nagarika
ನೀನ್
BNS.
ನಮ್ಮನ್ ಸೇವೆ ಮಾಡಿದ್ರೆ ನಿಮ್ಗೆ ಸೇವೆ ಅನ್ಸುತ್ತೆ. ನಿಮ್ ತಮ್ಮನ ಹೆಂಡತಿ ಸೇವೆ ಮಾಡಕ್ ಅಲ್ಲೇ ಅಣ್ಣನೂ ಇದ್ರು, ಅವ್ರ ತಮ್ಮನೂ ಅಲ್ಲೇ ಇದ್ರು, ತಮ್ಮನ ಹೆಂಡತಿನೂ. ನಿಮ್ ತಮ್ಮನ ನಿಮ್ ತಮ್ಮನ ಹೆಂಡತಿ ಮಕ್ಳು ತಿಕ್ಕ ತೊಳೆಕ್ ನಿಮ್ಗೆ ಏನು ಅನ್ಸಲ್ಲ ಅಂತಾನೆ ಅಂದೆ. ಅವ್ರು ಏನು ರಿಯಾಕ್ಟ್ ಮಾಡಿಲ್ಲ, ಆ ಅಣ್ಣನೂ ಏನು ರಿಯಾಕ್ಟ್ ಮಾಡಿಲ್ಲ.
Please, madam.
ನಾವ್ ಅಣ್ಣಗೂ
Please mute yourself.
ರಿಯಾಕ್ಟ್ ಮಾಡ್ತೀವಿ ಅಂತ ನೀವು ಬೇಜಾರ್ ಮಾಡ್ಬೋದು.
Please mute yourself. Your family affairs is.
I'll come later, madam. Questions I want to ask you. You please wait.
ಮಕ್ಳಿಗೆ ಒಂಥರ ನೋಡ್ಕೊಂಡ್ರೆ ನಮ್ಗೆ ಹಾಗೆ ಆಗಿತ್ತು.
Please mute.
Then under section 20 of DV Act, that is Domestic Violence Act, is also for claiming maintenance. All these acts are there. Now, for being a lawyer now, we have to file a petition. First of all, when the proceedings are not pending before any court, any proceeding, the Hindu Marriages Act is not available, Domestic Violence Act is not available, then 125 is available for maintenance, and it is also now very operative in nature. It can be filed before the magistrate court, and we can get maintenance under the provision of section 125 or 144 new section chapter 10 of BNSS Act. So therefore, my humble request for you, 125 is always the easiest method to prove that we are neglected. That is one first word. Second word, my husband or the son is having sufficient source of income to manage and maintain, to be provide old age parents, children and wife. So that we have to source of income we should prove. And duties cast upon him, that is also there, the judges going to assess our based on the evidence. Likewise, section 125, there are children, wife and old age parents. All these persons going to claim maintenance against earning members of the family. So this is not only wife, not only children, but also parents are also entitled to claim, but not husband. Under section 125, it is restricted. Husband is not party to the proceeding under section 125 of CRPC old. New section is 144. So therefore, this is the section has been used for the purpose of getting easiest maintenance. Immediate relief is available for us. If notice is served, immediately we can press the court. We can request the court, sir, we are already sufferer. We are not having any source of income. We are dependents upon him. He has to maintain us. So therefore, completely he has neglected us. Kindly maybe grant maintenance. Definitely, interim prayer is also going to be grant, and also the maintenance going to be grant under section 125. New section is 144 of BNSS Act. So likewise, Domestic Violence Act, there are several proceedings are pending now. Domestic Violence Act, always initiated by the aggrieved person. You see, mother is aggrieved, wife is aggrieved, so children are also aggrieved. They are the persons. Those who are unmarried daughters, she is also aggrieved person. Aggrieved person, they shall file their petition for maintenance or domestic violence, harassment made by the husband, father, every son, everybody you can file application before the appropriate court. Now at Bangalore is concerned, that is traffic court managing all the affairs of domestic violence proceedings at Bangalore. But in other courts, JMFC, that is Judicial Magistrate First Class Court, Senior Division or Junior Division, they are having jurisdiction to entertain the petition under Section domestic 12 of the Domestic Violence Act. Then automatically pendent lite you can file under Section 20 application to claim maintenance before the concerned proceedings. You can domestic violence also claim damages, including permanent alimony, everything you can claim in the domestic action. But interim maintenance is concerned under Section 20, you have to file necessary application during pendent lite of the proving of domestic violence, aggrieved person, wife, children, mother, father, all the persons are aggrieved persons. It was declared under the new project called as Protection from Domestic Violence Act. So these are the sections available for maintenance. So my experience of long experience, Section 125, it is very clear. Ought to have to give for due to negligence made by the son or husband, they have to liable to pay maintenance. It is easiest proceedings because one or two paras or one or two pages, it is sufficient under Section 125 because you have to prove only negligence. He has neglected to us. He has neglected to maintain us. He has not taken care of us. So therefore, maintenance easily available for you under Section 125. Now, these are the sections are available for you. I think you have all noted. Section 24 is the interim maintenance proceedings between the relating to the marriages. Section 24 is pendent lite application you can file. Section 25 also you can file permanent alimony if divorce was took place. Even permanent alimony is also can be granted because why permanent alimony? Why your mind should go for this? Because students, now your son is going to study MBBS or anything, but permanent alimony is available even though he is a major. My mother could not able to give us so much money, who is depending upon the, it is duty cast upon the father. He ought to have to give all the education purpose. He is liable to pay educational expenses. Therefore, permanent alimony is also required. If the mother is or wife is not ready and willing to join with him, therefore permanent alimony under Section 25 we are claiming. This is Hindu Marriage Act and Hindu Adoption Act. Now I have stated 4 sections are very, very important. 18, maintenance, wife, widow, daughter-in-law, and maintenance of children and aged parents and dependents. These are the 4 sections, 18, 19, 20, 21, under the provision of Hindu Adoption and Maintenance Act 1956. Next, Special Marriage Act 1954, only Section 36 and 37, pendent lite alimony as well as permanent alimony under Section 36 and 37. And 125 is concerned elaborately. You can execute the order immediately through the police only. So therefore, Section 125 and DV Act is also available for you. Section 20 for monetary relief entitled by us. How neglected? Because all the wordings wherever all this section used, stating that earning negligence and completely he is not managing, maintaining the affairs of the family. Therefore, all the sections are one and the same, but you, at your instance, that advocates intelligence, where should I go? Immediately relief, which I am going to get. That you can assess the parties and you can file the cases for maintenance before the trial, before the courts, wherever jurisdiction is available. Now, I think now recent all the affairs available for maintenance. Now, sir, criminal case filed, whether while filing the criminal case, whether she is entitled for maintenance. So some of the several judgments are passed. The what is the veracity of the criminal act done by him? So there is no possibility at all available reunion each other. Then the criminal case should be assessed only the appellate courts. Likewise, we are questioning the proceeding before maintenance proceeding before Honorable High Court of Karnataka, stating that the harassment is already made. She is not entitled for maintenance because in her statement itself, she has harassed us and she wants to take action, all the family members. Therefore, she is not entitled maintenance. You can question by way of filing the petition before Honorable High Court of Karnataka directly under section 482. That is the inherent power. You can move the matter, those proceeding. So therefore, the criminal section is criminal acts if taken wife or any other person. You can question inherent power before Honorable High Court of Karnataka. So now all these proceedings, how you are going to draft? That is also very, very important because being a student, being a budding lawyers, how to draft? You must collect the information. How you are going to collect the information? While coming a client before you, you must collect marriage wedding card, marriage photos, then collect the income of the persons. And now I want to say, wherever maintenance going to claim by either of the parties, they must file their affidavit. Assessment liabilities affidavit they should file. That is, mandatory provision has been ordered by Honorable Supreme Court because the assessment and liabilities, if they have not filed, the maintenance cannot be granted. That is the judgment is passed. So therefore, wherever the maintenance claim, they must file their assessment with bank account of 3 years account. They should place before the court, this is the earnings of husband, or individual affidavit they should file. There is no any accounts available for me. Therefore, I don't have any assessment. Likewise, they shall file their affidavit. And if it is proved, if anything, affidavit accounts is available, but she wants to suppress the fact, then automatically the court is going to thrown out easily. Applications are going to be dismissed. So likewise, you must collect marriage card, earnings, and first if a client comes to you, you should get his particulars. Now male member is coming before you, saying that, sir, I am harassing by the wife, demanding money, all these things. Then you have to file restitution of conjugal right. Restitution of conjugal right, maintenance cannot be claimed. There are several judgments. But some of the judgments, school expenses, all these things available, it can be ordered by the court in restitution conjugal right also. So likewise, you have to assess the clients who are coming before you. Then address, their address, collect the address, Aadhaar card, now it is available for you. Now next is marriage wedding card. Next is earnings of the person. Then affidavit, passbook, all these things, document you should collect before filing any case, any wakalat before the court. This is the practice you have to render. Then only you can, whatever he is saying, whatever information collecting from the client, you should file affidavit before the court. Because if you add something more, he do not know what is what. Have you stated tomorrow cross examination? You may lose the case. Have you stated so? No, sir, I have not stated. My lawyer has written without my knowledge, sir. Then automatically it is very difficult for you. Therefore, you must collect the information. By getting the information sitting in front of you, it should be writing short history. You should write on paper. You need not worry about the paper, but you must write something, address, everything. Then only you can easily find out, easily you can file a case before the court. This is the practice we are also rendering. I am requesting you, when you are coming as advocate, you must collect the information by getting him before you, and all the papers you should prepare, and then only maintenance case you should go. Independent cases. Now, all these things you are saying only pendent lite. Yes, I have stated only pending proceedings, Hindu Marriage Act. Permanent alimony, it is separate, independently you can file. But Adoption and Maintenance Act, that is the section 18, 19, 20, 21. It is independent proceeding. You should file before the court. 125 also you can file before the court. In other proceeding, no, it is only a pendent lite. That is, during pendency of any proceeding between husband and wife, you are entitled to file applications pendent lite. Therefore, Maintenance Act under section CRPC, under section Hindu Adoption and Maintenance Act, directly petition you can file before the court, but not under other acts. So, therefore, whatever maintenance available, proceeding, easy proceeding, you can draft yourself and file the court before the court. Need not pay the court fee also. If you are claiming amount is 50,000, then you are liable to pay. But it is not, nobody is going to mention the amount. It is requirement you can assess in your petition. All the things you should draft, because your address, facts of the case, how much you are need, then how he is earning, and what is his earning. All the facts should be brought in the petition. Then only you can file petition before the family court or before the official courts. This is the today's topic, maintenance, how to get. Is there any question? You please ask.
Sir,
Good
good
evening,
evening,
sir.
sir.
This is Jacob.
Good
Jai
evening.
Janardhan.
Sir, suppose husband and wife are from two different states and they are married under Special Marriages Act. Where will be the jurisdiction, sir?
Recent one judgment is available for, I think you have gone through in paper also. The marriage, first thing, jurisdiction is available where they have last resided. Last residence is the jurisdiction. Because now
Okay.
I married at Davangere. I come over at Bangalore. So since marriage was took place, I should not go there because last resided together at Bangalore only. Therefore, Bangalore is having jurisdiction.
Okay. So suppose husband, the last resided place is Bangalore and the wife's native place is somewhere in the North India. For every hearing, she has to come to Bangalore.
Sir, one thing, Honorable Supreme Court, Honorable High Courts already dealt in that matter, sir. It is
Okay.
not possible women to come because
Ah,
we are filing under section 24 of the Act to get it transfer cases from one court to another. The
okay.
always woman is not forced to come where exactly you
Okay.
are available. It
Okay.
is not possible husband's petition. She can uh, protect her interest where husband going to file. She can claim transfer of cases. Recently, I got it transferred from Orissa to Karnataka. Hindu, uh, Hindu, both are Hindus. Divorce petition has been filed Orissa. He is a security guard
Oh,
and he filed there. Then wife is
oh,
residing at Bangalore. Then I filed petition
oh,
at Honorable Supreme Court. Honorable Supreme Court ordered transferring the case at Bangalore. So likewise, it is always women's protection is main criteria. Therefore, petition, if I have filed divorce petition at Bangalore, she is residing at Bombay.
yeah.
She can move the matter for transfer from Honorable Supreme Court only state to state or within the state, only High Court is having jurisdiction.
Okay, sir. Thank you, sir.
Welcome.
Clear.
Sir,
Grateful.
sir, for the male clients, right? Nowadays, like it is frequently happening, the wives harasses the husband family and they leaves for the maintenance. So, what will be the relief that
Sir,
husband
relief
family
is
has in these
relief
cases to
always,
protect?
sir, available for you. Now, yesterday I cross-examined one guy. She is working in company. She is drawing 2 lakh rupees. She has not filed any maintenance, interim maintenance required to her. But she is drawing 2 lakh rupees. Therefore, she has not filed any application. Now, she wants to claim damages. That is, one case she is filed protection from Women Domestic Violence Act. That is, one case is filed. She has claimed maintenance and she has claimed damages more than 3 crore rupees against husband, in-laws. She has already filed a petition under domestic violence. Another petition also filed before the court, restitution of conjugal right. Now husband is not required because all the defense is like this. What I have taken defense in this case, she has filed all the petitions after filing the criminal case only. She intention behind her mind behind for filing the cases should be looked into because she has filed criminal case, they are beyond bar, they have been sent. Now, is there any possibility to say that she is going to come back to the house of husband? It is not possible. We can place the material, sir. This is the thing is happened. She has come over. She has harassed as if like it is not possible to reunion each other, and we have tried our level best. Everything is happened. Panchayati was took place. Now she is earning lady. Therefore, she don't want. Now she wants to claim domestic violence as well as restitution of conduct. Is it is possible to say that? No. So therefore, being a lawyer, we should protect the interest of our client before the court. The subject matter should be deep. Just you get it assessed based on the evidence only.
Thank you, sir.
Well,
Hello, sir. It's Mahesh here. Sir, prenuptial marriage agreements, are they completely valid or partially valid in India?
no, madam, agreement is not available in our any IF law. Hindu Marriage Act, Special Marriage Act. Now I think you have read over. I am daily. I am reading the paper. Now this what is called as both are living together without marriage, and
Yes, sir.
that has been recognized now, Supreme Court. Honorable Supreme Court recognized. Let them live together, but they should not file any petition before the court. That is the law. Because they are not married, they are living together. It is permissible, but they can't claim against each other harassment. Only they can claim criminal act against them. There is no any other law is permissible to them to claim as if they are having right or not. Living together is also recognized.
Thank you, sir.
Welcome.
Sir, in the event of the child custody,
Yes.
so when the husband files or wife files a child custody,
Child,
whose
yeah,
favor it
very
goes?
important question now. Custody of child as per the Hindu law, male is concerned 6 years. Female is concerned, it is not possible to hand over child to the parents or father, except if mother is under living adulterous life, leading her adulterous life, he can claim the daughter is also entitled for his custody. But not any other ground is not available for getting custody of female child.
Okay, sir.
But because one word I want to say, because tomorrow you must say that before anybody else. If you ask in Kannada, tanna tanavanna, tanna changes of nature for 13, 14, only before her mother, her grandmother. Therefore, all these things she can't explain before the father, changes of her status.
Yeah.
Therefore, this word already available, 1956 itself, it was stated why the child should not be handled. One example I want to give you. For child custody, female child is custody, I have filed in the year 1988, I think so. He is a fisherman. Wife died in an accident. Daughter is with mother's place, that is mother's mother, grandmother, female grandmother. She went there and she has started. Fisherman wants to file a case. She wants the custody of daughter because the mind of the father, I do not know. Because he has filed a case for claiming MUC case, that is motor accident claims petition. And tomorrow my daughter is going to get money. I am also going to get money. But tomorrow, whatever money she is going to get, it is going to be swallowed by the in-laws. So therefore, I want to custody. It is his mind. But however, I have filed. Then judge asked me, Mr. Nayak, one case is there. There is only one mens rea in that case, stating that welfare of the child. This should be looked into. So, female child is available for you and seeking custody. Why we are not going to hand over custody the female child? These are the reasons. The fisherman going at 4 o'clock and he hunting the fishes in the river. 8 o'clock he used to come. All the fishes he should sell up to 12 o'clock. Who is going to look after? This is one thing. Another thing, how the female child going to remain in the house alone? Protection of the female is concerned. Main criteria, therefore, female cannot be given in the custody of the parents because they are always, they have to go to their duties. So therefore, female is not going to hand over to the custody, but male child is concerned for further education purpose or further his attitude, behavior, conduct should be modified. Therefore, after 6 years, he can claim the male child in his custody because of these reasons.
However, in these situations, the father will be given visitation rights, sir.
Visitation right always available. Always available.
Mhm.
Always available.
So, in case the child custody is given to a mother or mother side parents, will they be able to take the child to foreign countries without permission from father
No,
or
no, no,
husband?
no. With permission only you have to take, sir. Because in my case also the same thing is happened. Foreign, he wants to take him to foreign countries. But there is a apprehension of her stated that he is going to permanently residing because he is having a green card in other countries. Therefore, I don't want to give permission to take the child. So likewise, we have to prove before the court, sir.
Okay,
Without
okay,
court permission, no child is taking away from the jurisdiction of the court.
okay, okay, sir.
Good evening. Sir, in case if the one of our client is Muslim, and will they come under the maintenance of Special Marriage Act or under the Mohammedan law?
Special Marriage Act and CRPC, sir.
Special Marriage Act, right?
Special
Okay,
Marriage Act, CRPC is available. Section 125, new section 144, BNSS Act.
sure.
So, you had initially told you'll have to declare your asset and liabilities as
Yeah,
well,
yeah,
isn't it? Sir?
yeah.
Now, what happens in case there's a non-disclosure of fact? One is
Automatically,
arguing,
the petition going to be dismissed, sir. The
yeah,
Supreme Court
that is
direction has
Section
been given very
93.
clear.
I was Section 93. I was given to understand where you also have a jail term,
Yeah.
right, sir? Now, is there any via media to figure out the income of an individual other than RTI?
No, 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 no. Because you see, it is
Okay.
declaration. It is declaration should be filed either wife or husband. Definitely they must file their declaration. Because when they are
Sir,
claiming right of maintenance, so therefore that declaration is required. That is the compulsory now. It is ordered by the Honorable Supreme Court, sir.
yes, sir. No, what I was asking
Hmm.
is there any via media to find out the income of an individual or a person working for a system other
Yeah.
than right to information?
Now yesterday the same matter has come to me. I have directed her to go
Sir,
detective agencies. Detective agency collected material
okay,
now. Huh? Now they are bringing
sir.
all the material from the company where he exactly is working. Yeah, those material we can file. And how you have to get, because
Yes,
steel is not available. Only simple particulars he has mentioned to us. Detective agency, we should examine, confronting his statement before the court to prove that this is the income. He is
Yes,
working
sir.
so and so place. All this he has detected. Therefore, I want to examine him. No problem in support of our case.
sir.
Yeah.
Yes,
Yes, sir.
yes, sir.
Thank
Thank you.
you. Thank you.
Excuse me, sir.
Yes, madam.
Sir, sir,
Yes, yes, sir.
sir, during the child custody, the judge won't ask the child whose wish he or she wants to say stay. As she as a female child, she is very close to her father.
Yeah.
Okay, and the judge won't ask the child.
Madam, one thing, minor evidence. Now, today, yesterday, I think judgment I have received. The judge can ask the question, and also the advocate cross-examine the minor child also by getting not in the witness box but in front of the judges. That is also mentioned. Yesterday, judgment I received.
Okay, okay.
Minor child also questioned by the judges or advocate also, man, but not in the witness box.
Sir, but because it is not necessary, na, the mother will behave properly with the child. Under whatever the circumstances, revenge also, the
Madam,
mother
the
can take custody of the child.
mind of the child should be assessed by the judges. Now you see, the always the child is accustomed and very lovable with the father because father getting so many things to him. Always he is in favor of father only. Mother can't get all the material because mother can't go outside. Whatever demand made by the children, that can be assessed only based on the evidence, madam.
Okay. And before passing any judgment, the child has to go through any counseling session or something to understand the matter better. So
Yes,
we
yes.
can come.
Now what happened at Bangalore, mediation center is there. Now already accommodation has been provided to the children and parents, those who are it is not possible to get the child visiting in some grounds or some that is called as gardens. It is not possible. Therefore, the mediation center is provided now. Always all the family court honorable judges now providing visiting right at Bangalore only mediation center.
Okay, okay, sir. So that will also be accountable now, whatever
Yes,
the
yes,
child's
yes,
statement is
definitely,
coming to.
definitely, definitely, definitely.
Okay, sir.
Thank you.
Sir, I have a question.
Yes, sir.
I'm Sham, and sir, are you Advocate Naik?
Yeah.
Okay. Uh, I just recommended by the good friend of yours. Later, I'll tell you. Sir, the thing is, the live-in relationship that you were mentioning.
Yeah.
And the Supreme Court, Honorable Supreme Court, has given the permission for permissible to live. How does the child come to the category in the live-in relationship? Because does that come under a legitimate or illegitimate?
Sir,
Since the Honorable
sir,
Supreme Court has
now
given a
legitimate, illegitimate word has been removed by Honorable Justice. Now she is sitting at Supreme Court because while she is elevated from Honorable High Court of Karnataka, she has delivered judgment. When accepting by both parties, it is their son or it is my son or it is born with us, that is called as he is a child only between them. Now, regarding acceptance should be there between the living relationship, the child if it is born. Definitely
okay, sir.
acceptance if it is available, they can get their name also. Living relationship.
So, what is the alternative
The
word for?
illegitimate, he cannot be declared as illegitimate child, sir, because both of them they are accepting. Definitely it is them to survive. He can claim he is a son of so and so, so and so.
But sir, the child may be a 6 years or a junior. It is under minor child or whatever. The decision of the judge regarding the divorce or a separation, and absolutely, because out of their relationship and experience, they're going for to all that request whatever. But the trauma, the children that they go,
Sir,
the
children
psychologically.
always entitled for equal rights, sir,
Okay.
against parents. Against
Okay.
parents. They may not be a parents because they are not husband and wife. Does not mean that they are not parents of him. Therefore, entitled the rights of the children under the provision of law. Now you see, one thing is there. Illegitimate, now you have asked me illegitimate. I don't want to say illegitimate. He is a son of them. Then his son is having right to get maintenance till his minority is going to be complete. Or education. Till education also he is entitled from their parents. That is called as parents, even though they are not married. But his right is available.
Mm-hmm. Anyway, thank you, sir. But anyway, I work with among the kids.
Please, sir.
I
Always,
know.
it is necessary for investigation. Everything is required. In law, I
Yeah,
think it is not going to end, sir.
I
It is
know
my
because.
experience. I am
Mhm,
also definitely every day I am reading, every day
mhm.
two judgments reading.
Mhm.
Because of this reason only, changes of law by way of judgment only. These are the precedents for us. Because,
Thank you, sir.
uh, because
Sir,
this,
sorry to interrupt you. The
right,
last question I would close regarding the alimony.
yeah,
Regarding the alimony, I just watched, one of the reels now for the education purpose. We get a lot of reels on the
yeah,
real decision how
yeah,
the judge handles and everything. I
yes,
understand there was a lady was claiming around 6 lakhs change per month.
yeah,
Now, just and the beautiful the judge gave a very solid contradicting question,
yeah,
asking her in which world that she's living 6.5 lakhs for her maintenance,
yeah,
and the advocate also the question from the honorable judge towards the advocate for her is asked, don't you have the common knowledge about how much the lady would spend for her and how come you could present this? Number one. Number
yeah,
two, what is the limit? Of course, the end of the day, it depends upon the honorable judge to decide where to wear. We all, irrespective of, we may have give 100% facts, there may not be 100% facts, but the judge
yeah,
has all the discretion to decide. But
yeah.
is there any benchmark, for alimony, for anybody who's
Just one
asking for
example I
maintenance?
am giving, sir, for you.
Yes, sir.
You see, now workman, the work who is working now, assessed by all the courts, 3,000 rupees per day. 3,000
Oh,
income has been, coolie also getting 3,000 rupees. That is the assessment made by the our judges. Now, in my case, now one case, I am fighting there. What happened? 7.5% children of entire salary has been given. 12.5% to the wife has been given. Now, total the out of his salary, this percentage amount has been ordered, and we are getting the same money. Now, still he wants to pay more money to her, but she is not ready to accept. What can I do? Tell sir. Even judges also forcing her to accept. Even he is going to pay 1 lakh rupees or 2 lakh rupees to you and daughter. Why can't you accept? Because what he wants to close the proceeding.
mm,
Therefore,
mhm.
nobody, if they can't accept, where should we go, sir? This is the things are happen because based on assessment of salary and as well as the income getting by the parties, sir.
Sometimes if there is no income at all,
That is 3,000 is available, sir, definitely. Because
thank you,
that
sir.
is the assessment has been made. I have asked several occasions. Yesterday, in one case, sir, he is earning only a 18,000 rupees. He is a security guard. 18,000, but ordered 7,000 to the wife.
Mm.
So now can't say that it cannot be denied.
But this exorbitant,
Yeah,
exorbitant amount
yeah,
or lakhs and
exorbitant
lakhs.
now
Mm-hmm.
nowadays, sir. Cost of
Mm-hmm.
living. Yeah,
Mm-hmm.
High Court, if we are going to place any maintenance case,
Mm-hmm.
Mr. Nayak, you know the cost of living today. That is the question going to put by the judges.
But anyway, it's a very kind of a tricky
Yes,
decision.
yes, 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 sir.
Thank you, sir. Nice talking to you. Thank
Welcome,
you.
welcome.
Sir,
So I have an
as
example.
Yes,
Where husband and wife have stayed together for almost 8 to 10 years, and wife has earned and given approximately 1 crore. For an example, 1 crore to her husband in this all this 8 years of span when they were living together. Now they are going for the separation, and the wife is claiming for the maintenance.
yeah.
Once she's claiming for the maintenance, right? Can she claim the all the amount? Means whatever salary she has earned, right? She has given all her salary to the husband and
No,
in-laws
sir.
and other.
No, sir. No, sir. That is not the rule because she cannot say that I have given to you, therefore you are liable to pay. No. It is love and affection was there at early stage, and subsequently there is some difference started between you. It cannot be, sir. The court cannot order for that, sir. Because there are several judgments. Whatever earning made by each other, by
Mm-hmm.
individual, does
Mm-hmm.
not mean that they are liable to share each other. No. And they can't force it also.
Okay, because in the court, one of the court wife is
No,
telling
court
that I'm
cannot
not
order,
asking.
sir, because it is already
Okay.
lost. That
Mm-hmm.
whatever amount she has paid, and they have
Yeah,
spent
it's a
for their
transaction, sir.
life.
Transaction is there in the bank, sir, where she has transferred to her husband's
Yes,
account,
even
and
though transaction is there, only she can say that harassment how he has made. But yesterday I asked the question, have you paid any single money from your salary? No, I have not paid. That is the rule, sir.
Okay, sir. So, no,
Based on
wife
the
was also
question,
working.
assessment of
Okay.
question and evidence, sir.
Okay. Because wife was working, now wife is not having any money over
Yeah.
there. Even to fight the case, she's not having any money because all the money has been taken by the husband there. Okay. So all the gold and this everything has been taken.
Yes.
Okay.
Sir, wife is always entitled maintenance, sir, in all the proceeding, 125 proceeding, and in other cases, sir, alimony is available for her. Adoption and maintenance. Section 18, adoption and maintenance. 125, section 125 is available for her. Wife is entitled, neglect to maintain her because I don't have any income. He is having income. My income already taken and he is getting earning. That she can plead before the courts.
Thank you, sir.
Sir, can wife file multiple maintenance cases under different
Yes.
sections?
Therefore, I have suggested you now two cases, domestic violence case under section 20, she can claim. 125 she can claim. And only thing is, whatever order going to pass DV Act, whatever order going to pass 125, this can be placed before the other courts wherever she has filed. Sir, already she is getting. So what more she is required? They can file everywhere, wherever the proceedings are pending. Now, interim application going to file in all the courts, wherever proceeding is pending.
Okay.
Does not mean that once he is paying, why should he come before the court? No, this is not the difference. Every court is having jurisdiction to grant or reject because already she is getting for her maintenance is sufficient, then other court cannot grant. Other court may grant another 20,000 or 1,000. It may be also. It may be possible.
So during this the maintenance proceedings, sir, will the judges consider the other dependency on the husband, like
Yes.
parents' maintainability?
Dependency, rental income, property having by him, everything he is going to assess, sir.
Okay. And also the husband need to maintain the parents. That
If
also.
wife is having a house, now you see, she is having her own house, still she wants to claim rent from him. Rent is not possible to give her. So therefore, maintenance she is entitled for day-to-day maintenance, how much she has asked for against the husband.
Sir, it's Mahesh Korea. Sir, if at all the mother who has filed a divorce case has not requested anything for a son or a daughter in that particular suit, so is after the 18 years, can the son or a daughter go back and file a fresh case against the
Definitely,
property?
madam. Daughter is till her marriage. Daughter's stand. Till her marriage, she is entitled for maintenance. And son is concerned, educational expenses is entitled by him.
What about the properties, sir? If can
Property
he go after
automatically
18
their
years?
right is available, madam. But self-acquired property during that time it is not available for partition or for claiming right over the self-acquired property of the father or mother.
Okay, thanks.
Okay.
Excuse me, sir.
Yes, madam.
Sir, sir, I have a question, sir, regarding the Stridhan. Okay.
Stri,
So, Sridhan.
Stridhana. Yeah.
Yes, sir. Gold, na?
Yeah.
At the time of the marriage, the parent side also, the girl get the jewelry. The in-laws side also, girls get the jewelry.
Yes.
Correct. The in-laws family take the Stridhan from the daughter-in-law, saying that ki you are new to the house, thieves and XYZ, the things can be done. So you give your hand over your jewelry, whatever things is there, you hand over to us. Sir, now the in-laws are refusing to give the jewelry. They are telling that if we gave you, we will not give you.
Yes.
We just gave for the show purpose. So in this case, sir, what can
No, madam. It is a Stridhana, declared as Stridhana property only. Even husband offered to wife at the time of marriage. Those articles, Stridhana property only, that is already declared law.
but
Whatever
it is not
property.
in writing now what they have given, what they have not given. So how
Madam,
can we claim?
how, only based on assessment of evidence, because you see, photographs are available for you. Those articles they have put to her, these articles are not handed over to me. You can place your photographs and claim those articles from them.
Sir, but they can claim now only for show purpose in front of the society
No,
we
no, no,
gave her
no, not
marriage.
show purpose, madam. It cannot be said that offered at the time of marriage, bridegroom. Therefore, she is entitled, she is having a right over those properties.
And if any photograph and this thing is not available, so she's not entitled.
Yeah, madam, it is based on evidence. What are the article given and all these
That's what
things.
the any time limit is there to file a case. She should get
No,
the
madam,
Sridhan
no
like.
time limit is available. No time limit for maintenance and return of articles.
So after 15-20 years also she can file a case against her in-laws.
If documentary evidence is available for you, definitely you can claim those articles.
Okay.
Okay, sir, I have another question here. Similarly, if like the girl's parent gives some, gift to the boy,
Yeah.
is it also part of Istridhan?
No,
Can
no,
they
no,
also ask
no,
it
no,
back?
no, no, madam, because
Or
no,
yeah,
that
if
is
they give it
not
to
the
the boy's
Sridhana.
parents, will it also be amounts to Istridhan, or can they claim it back?
Madam, it is not possible from the boy. You
Girl
can't
side.
get it. Girls only you can get.
No, no, I'm saying the girl's parents can ask it back, filing a case that we have given to the boy a chain or a ring or
Yeah.
anything. We want it back, so they can claim.
No, it is not possible. No such cases are available. But exchange offer is available, madam. Exchange offer at the time of
Okay.
divorce. That is available.
Mm-hmm. I see you have been talking only about one-sided laws, which are more in the favor of, wives.
Yeah,
But I don't hear
maintenance.
anything which is in the favor of men, the harassment they undergo. So what is the remedy for them?
Man, domestic violence is there. You can claim a huge amount against husband also.
Not against husband. I'm asking from the husband side, like what a husband has a channel to work on so that
Well,
he gets remedy for himself and his
based on
parents.
evidence, madam, that's all I can say. Because always maintenance from husband side only, not for.
Okay, if the husband is not working, suppose
And
he is
then
laid off from a
automatically
company,
he is entitled, madam. Just I want to
so
read one
husband can also
section.
ask for a maintenance from his wife,
No. Husband can claim maintenance.
from wife.
Yeah, from wife, several judgments I got from wife. I
What
have
are the
given house
conditions?
to her. Just one case example I am giving now. She is earning lady. I have
Hmm.
given house to her because two children are there. She is earning.
Hmm.
He is not earning because he
Hmm.
is retired from service and permanent alimony, permanent amount he has taken from his employer. Now unable to live in the society. When she is enjoying house property and she is still in service, I got the amount from her, 10,000 paying by her, maintenance towards her husband.
So
We
basically, in a
can claim
practical,
that.
yeah, in a
We
practical
must show,
situation,
we
right?
must show that I am not having any earning.
Okay. Is it like also like we have to show that person is disabled or he's
Yes,
not able to
yes, yes.
earn or
Disable,
mentally ill or depressed?
yes, disable and sick, and as
Hmm.
well as some orphan, the uh, amputation, everything is
Mm-hmm.
available, madam.
Okay.
Maintenance
Okay.
available for them.
Sir,
Okay, sir.
in nowadays, like it is happening in majority of the families, like the wife, not liking to stay with in-laws or disrespecting the
Yes.
husband side relatives and parents.
Sir, I think
Is there,
I am also having knowledge that now the relationship is far away from each other.
yeah.
I think all of them are earning,
Hmm.
and I got earning in those days only 25 rupees. Now today I am getting, no doubt, but still my son is earning more than uh, 10,000 or 1 lakh or 2 lakhs. But I can't say that my son is earning so much. But I must be happy. That's all. He is also getting handsome earning. He is not dependent upon us. That too we must maintain, sir.
No, not that is not my question
Ah,
actually. In
yes.
nowadays, in majority of the families, the wife side is harassing the in-laws, right? They don't
Sir,
stay with
sir,
in-laws or
always is
disrespect.
there,
Is there any?
but I think so. Every day you go through the judgment. Now, Supreme Court directly stated wherever the harassment relating to the dowry is concerned or family matter is pending, definitely it going to be clash against the in-laws, sir. Every day, sir. Supreme Court deliver good judgment, two judgments recently. The other family member should not be included in criminal cases.
Okay.
If
Sir,
you want, you
also,
collect from me. I am having so many judgments.
okay. Sir, you mentioned the parents also allowed to claim the maintenance, right? The
Yes,
old age parents.
yes, old age
So,
parents at C section 20, old age parents and children, they can claim Hindu Adoption and Maintenance Act and CRPC, that is one section 125. The
in
old
what
age parents, they are
conditions?
entitled, sir.
In what
Sir, here
conditions
I
they
have
are?
question. Sir.
Either
Sorry to
in-laws,
interrupt.
either daughter-in-law also they can claim. Daughter-in-law, if she is earning, definitely they can claim. Old age parents.
Sir, I have a question over here. Sir,
Yeah.
if the parents disown the male child after 15, 20 years, when they are not in a position to earn for themselves or they are not able, then also they can come and claim for the maintenance rights?
No, no, no. After, I think, 18 years, male child is not entitled, madam.
No, no, sir. If parents disown the son child,
Yeah.
okay, if the parents is not speaking to him since last 18 years or 20 years, and so out of the blue they come and they can collect the maintenance rights because they are their biological child.
If he is earning, madam,
No, but the parents have disowned him.
now they cannot say that.
The parents have disowned the child, sir.
No, no, no,
They
no,
are
no. No, they cannot to say that disowning. How can they say that, madam?
no, yes, sir. Because see, sir, recently I was studying something, so I came across like
Yeah.
it's been 18 to 20 years. The parents are not talking to the child.
Hmm.
Okay,
Yeah.
they are like he is around so 45, 48 something,
Hmm.
and out of the blue they have come and asking for their you should come and take care of us. We are getting old, but and he is solely and only made by himself.
Madam, that is the law
Now
is
he is not
available,
ready.
madam. Law
Sir,
is
no, and
available. Law is protecting the old age parents under Section 125 and Adoption Act, that is Section 20. Old age parents, it is their right, madam. They have to claim,
but
even though
parents,
even though
parents
they
didn't
are
take care of the
even
child now.
even though they are separated from each other from so many years, does not mean that they are not having right to claim maintenance.
That's what my question, sir. They are entitled to get the maintenance if
Yes, yes,
they claim
definitely,
it.
madam, definitely.
Okay, okay, sir.
What?
Can
So,
wife
Again,
parents can wife
what about the
parents file?
concealment? Yeah, sorry. So, what about the concealment of income? Like, suppose if the wife has hidden the facts
Yeah.
and has not disclosed her income in the affidavit, right, as per the Supreme Court, that
Yes, yes.
Rajni thing. So, what is the remedy for a person? Like, how it
Only
should be
I am
approached?
now
Is there any
just one
provision?
example I have given. Detective agency, you have to engage, get the information, and application to where exactly he is working. If
Not
you
he,
are
she. I'm talking about concealment of income from wife when both are
wife,
working.
yeah, yeah.
So, because court gives maintenance based on the parity of women's earning and the men's earning, right?
And
Husband and wife
now
earning.
what happened, my lord, in such cases, I have filed application under section 96 of CRPC, calling the employer to produce her employer how much income she is getting. We are making salary, or even though she has concealed, we must get the information through the court also, and
Like how?
and
Like
bank
suppose he has
account
hidden
details
the.
also. Bank account details also we can get.
So is there any section which we can use
Say
like
CRPC
240,
96 available. All the proceeding we can file application, madam. Not only in CRPC but also application 151, section 151. Now inherent power available CPC. That also we can file.
so 190, 151 and 96 is
Yeah,
something which
yeah, yeah,
person can use.
yeah, yeah.
So there is one section 340 also when people say a lot of false things, right? So is that
Yes,
also be
you
usable?
can.
Like what
That
is that
false
section
thing,
about?
only criminal action you have to take, madam. False affidavit,
Okay.
false everything. Fraud has been played to the court.
So what actually works in the code? Which is the best portion which really works in the code? 151, 96 or 340?
150 96 is available. They shall produce her particulars. That is the 96. 151 is
Mm-hmm.
also available. Always we are filing applications
Okay.
to get it particulars about the employment, passbook, everything we are. If we must
Hmm.
know where exactly her accounts are available, operating by her, and all these things we must particulars we should mention in the application.
Mm-hmm. Because generally, if you see, right, in Bangalore, like Atul's case also, right, which was
Yeah,
happened
yeah,
recently, like,
yeah.
right, how things have been hidden and how it was been, taken to a different channel. So
Yes.
that's the reason I was asking you such questions. What is the provision a man has, right? Like what right he can execute
He can
for his
he
own
can he
benefits?
can file application, madam, if doubt arises.
Can wife
Mm-hmm.
parents file maintenance on son-in-law?
No, sir. That is not permissible, sir.
Okay, only son parents can file the maintenance on
Yes,
son.
parents can
Okay.
file against their son.
Sir, nowadays we are seeing like in one day they will be moving out after the marriage. Next day only they will just split out. So, is that a complete marriage? Does the court consider it as a complete marriage
Then
or?
you have to go for divorce. Only that is the rule, sir.
So
If
even in that
consummation is
scenario,
not there, if consummation is not there between them, they don't want to continue their life, automatically they go for divorce only.
why court grants the permanent alimony in such cases where the
Yes,
marriage did
definitely,
not?
sir. Once marriage accepted, since the day onwards, since that particular time onwards, she is your wife, legally wedded wife.
Yes, sir, but in case of alimony from both the side, nobody has any contribution for the growth of the wealth, because nobody has been living together to grow that wealth. So how does one or the other has an authority or legally they can claim?
Yeah,
For the
definitely, sir.
property?
Definitely, because they are legally binding persons. Therefore, they are each other having right over that.
Okay,
Sir, you
thank you.
mentioned a female child is entitled for maintenance until she get married, right? So what is the
Till her
definition?
marriage, sir.
So
Female
if
child.
she do not prefer to marriage, so that means the father need to maintain for lifelong? Or?
Yeah, definitely. If she is not married, definitely it is father duty to look after her.
Okay, so uh, okay.
And changes of circumstances stated in the law. If she has got a employment, if she is earning, he can file modification of that order.
Okay.
Sir, one silly question, sir.
Yes.
Suppose daughter again come under the divorce and all these proceedings,
Ah,
and usually daughter comes back to their parents' home.
ah.
In that circumstances, also the daughter can claim for the maintenance.
Sir, daughter always daughter, sir. Because if even divorce was took place between them,
Yeah.
but does not mean that divorce is also granted to the daughter. She is having right against mother, against father.
Okay. And son also will having this same.
Yes, yes, definitely,
So
definitely.
son has some age limit.
Till his attainment of marriage, 18 years.
18 years. Yes. Okay. Sir.
Right.
Thank you.
Thank you.
So I have a small question, sir.
Yes, please.
So the couple married and they were stayed for 2 years. After that, the lady has become pregnant. Then she moved from her husband. Then after 10 years, she will come back, where husband is not accepting. What is the procedures, please?
Restitution, madam. Restitution of conjugal right. There is no any
Like
limitation for
what
that.
exactly, sir? I
No,
don't
but
know.
after 7 years, it will become the marriage will become this. No, sir.
Sir, you
7.
have to file, that is the ground for willful desertion. Willful desertion
But
is there.
nothing, no file, no nothing is there. So they, yeah,
That
like
willful
with their
desertion.
knowledge, they moved separately.
13B, 13A is the cruelty, 13B is willful desertion.
Okay. In this scenario, after issuing the restitution, filing the restitution, still the husband is not allowing the wife. So what is the remedy for the wife?
Then divorce.
But wife don't want to go for divorce. She wanted to stay with husband. So
Sir, always, sir, that is now restitution is not only based on the evidence. The court can grant restitution. It is executable order.
Okay.
But sir, RCR we cannot means can we enforce it? I mean, it is enforceable because it's personal liberty is also there, no sir.
No. Restitution, if it is order, it is executable order. It is decided now, because in olden days, what happened? The both of them should not tie each other, because you can't force them to live. That is the law. Now that law is changed. This is the order passed by the court. You must live in a room. Whether you are going to enjoy your life or not, that is immaterial. But once the decree has been passed, you must live under common roof.
But sir, suppose wife don't want to live with the husband, and the order has been passed towards in the favor of husband.
Then
and
divorce.
So divorce means wife, husband can file the divorce.
Yeah.
And he can easily get the divorce.
Yes.
This is also one good way, sir, to get the divorce.
That is also one of the grounds, sir, because the judgment is passed, not complying the order. Therefore, you are entitled for dissolve the marriage.
So will it be considered as a contempt or it's a 13?
No, not contempt, because
Not
next
contempt.
step is, that is only step available between husband and wife.
And alimony is not required in that case, right?
Yes, definitely, definitely. You can, because she herself is not ready, oblige the order, how she is entitled.
Okay, so that's great. This is the good information, sir.
Yes, yes.
Sir, I have one very basic question. Suppose in 125 case,
Yeah.
right, there is a maintenance pass, right, and then the husband goes to High Court. There also, okay, it is dismissed. Then again, he goes to Supreme Court. So
Yeah.
in Supreme Court for 125 for the amount of maintenance charge, right, he pleads. And there they ask him for a mediation. So what happens if the mediation fails? What happens to the case? So will
Mediation,
Supreme Court revise
mediation
it?
fails means only based on the final judgment. Mediation
Right, but
fails is not binding on the court, madam.
right.
Whatever discussion was took place in mediation, it cannot be asked during the course of argument. Those words cannot be used. Those discussion cannot be used. That is the law mediation. Uh, all the because I am also conducted so many mediation, but whatever
Mhm.
discussion took place, that is not the evidence before the court. And
Okay. And if suppose if the wife says, I just want the maintenance to continue for years and years, I don't, though she's earning, she doesn't want to settle. She said it's good for me to earn a lakh or 2 lakh per month, which is asked by
then
family court
then
rather
then,
than
then
settling
you
it
have
down.
to go for further. What is the next, madam? If she is maintenance required, divorce wife is also entitled for maintenance. Now what is
No,
the
she's
next?
earning. I'm saying in that case, she's already earning, and she said it's a like a pension for me,
Yeah,
right? Why should I settle it with you, man?
yeah. Then you have to ask burden. Burden is there on you, husband, to prove she is getting income. Therefore, under changes of circumstances, that is the also law. It is available for you. Modification of maintenance.
So can Supreme Court do a modification of
Yes,
maintenance?
yes, definitely,
Or they
madam.
can simply
Definitely.
dismiss that, oh, mediation has failed, now we will dismiss.
Yeah, mediation does not arise at all before while addressing the argument. Just
Hmm.
you go and modification, you can ask for modification of maintenance.
Okay.
Okay.
Sir,
Because generally,
maintenance.
yeah, generally our laws are more of a woman centric and more of it is biased, right? That being a woman, I'm telling you. So I
Madam,
don't see any remedy for
for
the men.
for practice is concerned, definitely it is available for advocate also.
I have 10 different ways to harass a man, but for a man, there is no remedy. So that is very surprising in our law and order, right? So anyway, that's something surprising. Fine.
Sir, maintenance is granted just based on the income, or the whole
Yes,
properties of the
one third
husband is
salary can be attached, sir. There
okay.
are laws.
Mhm.
1/3.
Okay, and the properties also evaluated, or
No,
just
not
income?
property, sir. Property is not available for her
Okay,
except maintenance.
and what
Can
is the
PF also
criteria
be
for?
attached here, sir? PF?
PF is not attachable, madam.
Okay, they cannot apply for PF.
Yes,
Suppose person is not
PF
earning.
not attachable and pension is not attachable, but for maintenance concern, pension can be attached.
Okay.
Sir, excuse me, sir. Sir,
Yeah,
if like wife is working, okay, and she herself comes to court and tell that I'm working, I don't want to bother my husband, I can take care of my own expenses.
yeah.
But after 3 to 5 years, she's unable to work for some or the other reason. So after five,
Please,
3 to 5 years, she can claim maintenance from her ex-husband.
definitely, madam, definitely maintenance she can claim. And
Okay.
one thing, what correct, if only one lacuna is available in this case, if the compromise was took place between husband and wife, she is not entitled for maintenance, madam. Compromise took place.
Means
Okay.
13B. Means 13B.
13, not 13B.
Then compromising
If
for what
now
sense, sir?
maintenance case I have filed,
Ah,
now she wants to come before the court. Sir, we are already agreed for that. We don't want to claim any maintenance. If that order is passed, she cannot file any maintenance petition.
in the future?
Yes, only under the circumstances that is also available for ailment is concerned. If she is sick or something is happened to her, she can claim maintenance.
So, like
Because
once the judgment is passed that okay, wife is earning and she is not entitled, she herself is not claiming for the maintenance, and she cannot once the modification she cannot apply for, like I'm unable to work or something, I'm not able to
no,
like
another
a job in
separate petition should file, not modification. Separate petition, separate reason should be confined in our case.
okay.
No,
And any time limit is there? Under how many years she can file the complaint?
no limitation, madam.
And
Suddenly
if she is married to other person,
if suddenly she is met with an accident, she can claim.
and if she is married to other person,
No, she is not entitled. But
no, no.
She is not entitled.
Sir, sorry, sir. You mean to say if wife get married, if wife means divorce proceeding is going on or a maintenance proceeding is going on, and one maintenance has been already granted, and after that she suffered with some disease or some problem, some health problem, that also she can ask for more maintenance. Is that the way you are saying?
Sir, definitely changes of circumstances, changes of facts. She is
Okay.
entitled to claim maintenance.
So in that case, sir, husband can take the medical insurance for wife also, and she can claim it from there. Is it possible, sir?
Yes, definitely, sir. Having possibilities.
Okay, sir.
But
Thank you, sir.
Sir, I have one basic question. Suppose like the husband he's paying maintenance and he now wants to go for a higher studies, or he's an engineer by profession and he want to pursue law. So can that be like maintenance can be suspended for some time till he completes the law or any other degree if he wants to pursue, like for 2 years, 3 years or 5 years, or still he has to pay because he leaves his job and does some studies, right?
yeah.
So what will happen in that case?
Now you have to change the sub circumstances. See, since I am not having any income during that period, kindly maybe suspend this order. You can claim before the court. Where the court has ordered, the same court you have to make an application.
Okay, so court can consider that kind of application and appeal, right?
Definitely.
For studies, men can try this option also.
Yeah.
Okay. Good.
Sorry, is there any question now? I think last question you please ask. Discussed everything, I think so.
In case husband turns or he get disability, like he's not movable or some kind of injury, accident, where he's completely bedridden. So in that case, how the maintenance proceedings will
He can ask for modification, sir. If the maintenance order he has suffered, he can place the material. This is the accident was took place. I cannot earn as if what earning was there. So therefore I am spending money towards my health condition. All these things he should place before the court and get the modification of order, maintenance.
Okay. And what is the criteria for determining the permanent
Only
ordinance?
salary, sir, salary income.
Not property.
Yeah. Thanks, sir, for your cooperation. I think you have got the everything available for you relating to the maintenance under what provision. These are the provisions are available for you while you are in practicing. Please note down all these sections tomorrow, because maintenance not only one book, that is CRPC, but also available in other cases. You please look into that, be steady, and helpful for your practice, but also your examination. Thank you very much.
Thank you so much,
Yeah,
sir.
extremely, we are
Thank you.
very much
Thank
thankful
you,
to you,
sir.
sir,
Thank
for
you so much.
sharing your experience and knowledge.
Thank you,
Thanks
madam.
a lot, sir.
Thank you, sir.
Yeah, thank
Thank
you
you
so
so
much.
much,
The
sir.
way you
Thank
speak,
you.
sir, I like very much, sir. Thank you so much.
Thank you.
Thank you.
Thank you, sir. Thank you.
Right.
Thank you, sir.
Question